We have a 73-year-old patient with a history of hypertension, depression, and BPH who was brought in by family for erratic behavior and wandering. The patient has been progressively agitated for no obvious reason and has been incredibly forgetful. An extensive workup is done in the hospital, and he's diagnosed with Alzheimer's dementia. His family is unable to care for him at home due to financial issues. He lacks capacity to assign a DPOA and also lacks capacity for disposition to a secured nursing home. He is highly ambulatory. What type of conservatorship does he require? Lanterman Petrus Short, LPS, for those of you who don't recognize that, or probate conservatorship. So this is what we call a VA classic. Give you a little bit of time. Hello, CCU. I may not have anything on LVADs on you guys, but I know this stuff really well. All right. The answer is probate conservatorship. So we're going to actually review the types of conservatorship. This is hopefully going to be very valuable for all of you. So what the heck is conservatorship? Basically, an individual will make decisions on your behalf. So LPS conservatorship is meant for patients with psychiatric illness that affects their capacity. So if they have a psychiatric illness, but it's not affecting their capacity, and they lack capacity for another reason, you don't actually LPS conserve them. This obviously can get very messy, and it's up to the discretion of the psychiatrist to really figure that out with you. So probate conservatorship is meant for patients with non-psychiatric illnesses that affect their capacity. So things like dementia. So DPOA, we see this term used all the time. It stands for durable power of attorney. What a lot of people don't realize is when you're assigning a DPOA, you assign one for healthcare, but you actually have to explicitly assign one for finances. If you don't do that, they only have control over their healthcare. If you have a DPOA that's specific to healthcare, it is called a healthcare agent. When a patient suffers from dementia, we try our hardest to determine if the patient specifically has capacity to assign a DPOA. Because if they do, and they're able to assign a DPOA, that person can now apply for insurance and get them placed in the right area. If they lack capacity to assign a DPOA, you now must go through the courts for conservatorship, which can take 9 months to a year. So this one is short because all the information is at the end. So this is about LPS versus probate conservatorship. DPOA information can be found in advance directives, living wills, or other legal documents. So in CPRS, you actually have to go to Tools and Vista Imaging, and you will see a bunch of scanned stuff, including PFTs and advance directives. DPOAs specifically have to be assigned for healthcare and or finances. So it's not just automatically for both of them. And capacity to assign a DPOA should specifically be assessed if no DPOA has been already assigned, because this can help you skip a lot of the steps of going through the courts. Dementia would not fall under LPS. So let's review the two. So the indication for LPS is psychiatric conditions. For probate, it's non-psychiatric conditions such as dementia. In rare situations, psychiatry will place those patients on LPS conservatorship. This is a really interesting point. So specifically for psychiatric medical decisions, in LPS, the conservator can give consent for psychiatric medical medications. In probate, the conservator may not give consent for psychiatric meds unless the court has approved it. Now, this exists outside of the state of acute agitation where you'll have to do what you have to do because the patient is potentially at risk of hurting themselves and others. But generally, for medication titration, you're supposed to go through the court. For non-psychiatric medical decisions, if someone is LPS conserved, the court has to decide. So if you have a patient who has terrible schizophrenia and an abscess and needs IV antibiotics and the patient is refusing, you actually have to go through the court system. Or the LPS conservator needs to talk to the court and sort of do that. For probate, the conservator can give consent. For the finances, it is rare for the conservator to control the finances in LPS holds, and the public guardian can act as a payee. On the probate side, the conservator can make decisions about finances. So that's all tucked into the conservator part. Now remember, if you assign a DPOA but not for finances, you're stuck. You actually have to assign someone independent to make those decisions. Finally, how long does this last for? LPS actually expires every year. Now, there are notable exceptions such as Amanda Bynes and Britney Spears, and that is a point of contention. That is very rare. Probate, however, is indefinite. So it's pretty incredible. All of this comes from a handout from the County of Fresno Office of Public Guardian. So what I can tell you is this applies to California. I don't know how this applies outside of our state. Dana's saying that she has a dementia patient who's LPS conserved. It happens. So what should theoretically happen is they should let the LPS conservatorship expire, and then they should apply for probate. Now, when you have a patient who is in that situation, do you hold them here for 16 months while you figure that out? The system really doesn't favor doing that, so folks don't switch them over. And they just keep renewing the LPS. That was a lot. Questions?
Can you talk about what you do when you have a probate conserved, or sorry, an LPS conserved patient and the conservator is not reachable and you need to make an urgent medical decision?
That's an excellent question. I'm going to do something unprecedented in fast facts and ask you to answer that, Dr. Chuang.
I was asking you to answer that. No problem. I asked that on purpose because it comes up all the time for us at the VA. And I know that Katie Fruin, especially I see on the call, feels this acutely because we dealt with a situation recently. So essentially at the VA, if you can't reach the conservator, they're considered unrepresented. Or if the conservator says, I don't have medical powers to decide that, it has to go through the court, that timeline is too long. So you actually have to then decide if that procedure or decision is emergent or urgently needed for the benefit of the patient. You go through bioethics, and then you have the attending of service and the chief of that service. So often it's like the chief of staff or the chief of the medicine department have to agree and assign this note saying that we're going to proceed with the procedure for the benefit of the patient. And then it's what we call two-physician consent.
So I think it's important. Thank you so much. I think it's important to know the basics of this. And of course, if you have questions, that's what the hospitalist group is here for. The MOD can also help with this. All right, that's it. This was an extended one, but a very common and important one. Thanks, everybody. Have a good weekend.
Thank you.